All right, to help us further unpack what this actually means for South Africa, let's now welcome legal expert, Advocate Jazz Vilakazi. Advocate Vilakazi, a very good afternoon to you. Thank you so much for your time. So does this ruling, in essence, then expose weaknesses within South Africa's extradition processes, or is it simply just a legal setback that can still be challenged?
Thank you for having me on your show. It is a setback indeed. However, it is a setback that can be challenged. In effect, the High Court ruling by Justice Mvula indicated, amongst others, three pertinent aspects, I think he said. One of them was the fact that the documentation that was in the hands of the magistrate was of poor quality or was not authenticated, which is really weird. The second issue that they did raise was that the judgment didn't cover specific aspects. But the third issue, which is probably the biggest, was the fact that there were no guarantees that were given by South Africa to Malawi insofar as the extradition of the Prophet is concerned.
And Advocate, well, the judge who penned that judgment concluded that the request by the South African government is, and I quote, tainted by bad faith, political motivation and oppressive delay without protecting Bushiri and his wife, close quote. Right? So what legal framework can such a conclusion be derived, Advocate? Under what exceptional circumstances, basically?
I too am a bit shocked by that aspect of the judgment. I think that court, the Malawian High Court, actually overreached, as it were, because it was supposed to look into the merits of the matter. I don't understand the concept of it being delayed, because there is the statutory limitation in so far as the crimes that is charged with. They have a long time in which to run, and therefore there can't be this aspect of it was delayed. We must also remember that Prophet Bushiri did escape lawful custody, as it were, or at least he jumped his bail conditions and left the country. So I'm shocked by what the justice did. I'm not of the view that the High Court actually confined itself to the facts.
And I'm very glad that you brought that point up, Advocate, because I wanted to ask. I'm asking this previous question because the reality is that the pair were alleged to also have been in the country illegally. Hence, there was no detection at the ports of entry when they left the country under that suspicious cloud. Why can't then the Malawian court also not take this into consideration just for the interest of good governance as well as upholding our own immigration requirements? I mean, let the pair come in account to their alleged crimes. I can never understand why people want to stall the very processes that could potentially exonerate them.
Indeed, so I would agree on that point. I just want to perhaps put on the table that there's two documents that govern an extradition of a fugitive. The first one being the 1972 Extradition Act by South Africa, signed bilaterally with the country, the Republic of Malawi. And then the second one is the SADC protocol that was signed in 2002, I believe. Insofar as both are concerned, obviously there are specific aspects that the court must go through, or at least the authority on the other side must go through, in order to ensure that Bushiri, in effect, can come back. And for me, as I said, one of the surprising aspects of it was the fact that the High Court said that Bushiri would not get a fair trial, which is rather very strange, because if I can just take you back to the early 2010s, I believe it was, when Shireen Diwani was extradited from Britain to come and stand trial here. And he raised essentially the same objection of not having a fair trial. And however, we know that in South Africa, we have a ruling constitution that sets out the rules in respect of a fair trial in terms of Section 35. So I, for one, do feel that the Malawian High Court was also misplaced in that respect, because there is no way that a person won't get a fair trial, won't be able to present their evidence or challenge evidence that is presented by the state in court. So it is rather a very surprising judgment.
Very surprising indeed, Advocate. So since our Justice Department says they're still studying the judgment, really, what, if any, are possible legal options to further pursue this matter?
Yes, well, the Justice Department has got two ways in which they can further pursue this matter. In fact, it's three ways. The first one is that they can have the court processes run through. In other words, they can take this matter from the Malawian High Court to the Supreme Court or the Supreme Court of Appeals in Malawi. That is the highest decision-making court, similar to our constitutional court, and they listen to appeals that come from the lower courts. So that's the first one. The second one, according to the extradition treaties that we have and the SADC protocol, is that we can resubmit a new extradition request to Malawi insofar as Prophet Bushiri is concerned, and perhaps in that way remedy some of these issues that are highlighted by the Malawian High Court. So those are the two main ways. There is a third way, of course, but I don't think that the Justice Department is going to pursue this. The Justice Department can actually ask the Malawian government to prosecute Prophet Bushiri in Malawi on charges and acts that have occurred in the Republic of South Africa. So those are the three. I don't think they'll take the third one because it probably is the most expensive out of all.
All right.
And what they want is to bring him over to this country to stand trial.
Well, we stand to see what the outcome is going to be. Advocate, thank you so much for that enlightening discussion there. That is Advocate Jazz Vilakazi there. He's a legal expert weighing in on the Bushiri extradition ruling.